Hi everyone. This video will examine two recent government publications on the COVID-19 vaccine in the workplace. The first publication we will look at is Advice to NPHET regarding policies relating to healthcare personnel who do not avail of the COVID-19 vaccination, prepared by HIQA and published on the 8th of April 2021. The second publication we will look at is Processing COVID-19 Vaccination Data in the Context of Employment, prepared by the Data Protection Commission and published on the 22nd of June 2021. Before we look at these publications, I would like to ask everyone watching this video and who has received written communication from their employer advising, one, that they must take or encouraging them to take the COVID-19 vaccine, or two, asking whether they have taken the COVID-19 vaccine, to please send a copy of any such written communication to info@ichr.ie in order that we can understand and thereafter provide guidance on the most common approaches being adopted by employers across the country. So we will start this video by looking at the advice provided by the Health and Information and Quality Authority, HIQA. HIQA are described as an independent statutory body who report into the Minister for Health. Since March of 2020, a special team within HIQA has provided what they refer to as research evidence to support the work of NPHET. In September 2020, it would appear that NPHET began writing to HIQA to ask them to provide advice on specific topics. The topic we are looking at in this video is what policies, mitigation actions or initiatives have been implemented internationally relating to healthcare workers who do not avail of the COVID-19 vaccination that could be considered by the Irish Health Services. So this particular guidance relates specifically to healthcare workers. It is important to note that frontline healthcare workers are generally treated differently to all other types of employees when it comes to the COVID-19 vaccine. As this guidance applies in particular to healthcare workers, those of you who are not healthcare workers may think this document is not applicable to you. However, this document should be of use in understanding the limitations placed on employers in settings other than frontline healthcare, given that this document outlines the measures that may be taken in the extreme. I've included in the description box to this video a link to the HIQA guidance document. The takeaways from this report are as follows. 1. A laddered approach should be used to encourage frontline healthcare workers to take the vaccine. This means an employer cannot go straight to the vaccine is mandatory. This laddered approach will start with nudges to influence choices, escalating to more restrictive steps through disincentives and the restriction of choice, for example through redeployment, with mandatory vaccination sitting at the top of the ladder as being the most intrusive step. The further up the ladder the state or the employer climbs, the stronger the justification has to be. The decision to step up the ladder is said to be influenced by the level of risk to patients from unvaccinated healthcare personnel. 2. Collection of data on uptake, reasons for refusal, ethnicity and setting is considered critical in order to ascertain where refusals may be higher than usual and any associated factors so that appropriate supports could be put in place. 3. It is confirmed that there is a data reconciliation project ongoing in Ireland which will facilitate the estimation of uptake rates among healthcare workers. 4. It is said that there is a duty of care for healthcare workers in direct patient contact to be vaccinated, with nursing home residents being considered to be at greater risk from unvaccinated healthcare workers, meaning healthcare workers in nursing homes are likely to come under even greater pressure. 5. It is said that mandating COVID-19 vaccination at this time may not be appropriate as this may act as a deterrent. As an aside, there is a general agreement throughout the EU that mandating a vaccination in law does not actually increase uptake. This is one of the reasons the COVID-19 vaccine is unlikely to be mandated in Ireland. The government in Ireland are far more likely to use coercive, underhand measures that are more difficult to challenge legally. 6. The measure of mandating the vaccine for healthcare workers was also considered in the context of public perception, and it was concluded that such a measure may be perceived as being overly harsh on a workforce that have had a particularly traumatic year. We know from everything that has happened over the past 18 months that keeping the public on side is very important to the government. And I suspect that this is one of the reasons the HSE backtracked on the announcement that all student nurses would be required to take the vaccine or have their placement stopped in April of this year. That said, while this point states that mandating the vaccine is not advised at this time, what I really take this to mean is, hey HSE, let's not be so silly as to issue a written ultimatum that ends up in the public domain and that makes you look like the bullies you obviously are. Instead, let's continue to roll out a policy of mandatory vaccination for healthcare workers, but let's not be so transparent about it next time. 7. Professional bodies such as the Medical Council of Ireland, Nursing and Midwifery Board of Ireland, Pharmaceutical Society of Ireland and also trade unions and third level institutions will be utilised to increase uptake of the vaccine. So do not expect any support from any of these bodies in the event you wish to decline the vaccine. 8. Finally, it was noted that, in particular, GPs and pharmacists play a pivotal role in increasing uptake of the vaccine, given the high number of direct contacts they have with the public each day. And if this cohort display any vaccine hesitancy, this could have the very real prospect of influencing the wider public. In this regard, the report states, there needs to be clear advice against healthcare workers spreading misinformation. Again, we know what is meant by misinformation in this context. From my engagement with GPs, I can tell you that any GP publicly vocalising their hesitancy to the COVID-19 vaccine or the COVID narrative in general is currently under investigation by the Medical Council. So if you see a GP voicing concerns, please support them because they are under enormous pressure to stop. The takeaway from this report is that a laddered approach to the vaccine must be undertaken by employers, and in most situations, mandating the vaccine will not be permissible. However, healthcare workers are likely to be treated far more harshly in terms of redeployment or termination of employment than any other occupation. While this document is not particularly helpful to those providing frontline healthcare services, it should provide a level of comfort to those outside of this sector. The second publication we will look at was prepared and issued by the Data Protection Office last week. This guidance note answers the question, what information can employers process in relation to their employees on their return to work? And in particular, can an employer lawfully collect and process information on whether an employee has received or intends to take the COVID-19 vaccine? The conclusion by the Data Commissioner is that, in the absence of clear advice from public health authorities, presumably this means the Department of Health, that it is necessary for employers to establish the vaccination status of their employees, then any such processing of an employee's vaccination data represents unnecessary and excessive data collection for which there is no clear legal basis. That said, it should be noted that once again frontline healthcare workers are treated differently to all other categories of employee, and there is a suggestion that requesting information on the vaccination status of frontline healthcare workers may be justified from a data protection perspective. In order that employees are fully informed as to the protection they enjoy under the General Data Protection Regulations in connection with the processing of their personal data, I will give a brief overview of this legislation now. The General Data Protection Regulations, which came into force on the 25th of May 2018, laid down rules relating to the protection of persons with regard to the processing of their personal data. The recitals to the regulations state that the protection of natural persons in relation to the processing of personal data is a fundamental right. Article 8 of the EU Charter of Fundamental Rights states that everyone has the right to the protection of their personal data, and such data must be processed fairly for specified purposes and on the basis of the consent of the person concerned or some other legitimate basis laid down by law. Information regarding whether or not an employee has been vaccinated constitutes health data, which is a type of special category data under the General Data Protection Regulations. In order to lawfully process health data, an employer must first determine a legal basis for the processing of such data under Article 6 of the regulations, such as on the basis of consent or to comply with a legal obligation. In this regard, it is important to note that consent under Article 61A is generally not regarded as a valid basis for processing an employee's personal data because of the inequality in bargaining power between an employer and an employee. In fact, in this guidance note, the Data Commissioner specifically states the following: the processing of personal data in the context of employment takes place in a situation where there is an imbalance between the data subject, who is the employee, and the data controller, who is the employer. Therefore, employees should not be asked to consent to the processing of vaccine data, as this consent is not likely to be freely given. This means that even if an employer asks an employee what their vaccination status is, and even if the employee answers the question, it is highly likely that this will be considered unlawful, in which case an employee could raise a complaint with the Data Protection Commissioner. So, if an employer can determine a legal basis for the processing of health data under Article 6, which appears unlikely in circumstances where the Department of Health has not provided any guidelines stipulating the necessity of doing so, then an employer should be aware that the processing of special categories of personal data, which includes health data, is generally prohibited unless an employer can avail of one of the exemptions under Article 9 of the GDPR. Furthermore, large-scale processing of special category data requires a data protection impact assessment, which must be carried out before introducing a policy relating to processing the vaccination status of employees. The guidance by the Data Commissioner also confirms that the decision to get the COVID-19 vaccine is voluntary, and this further suggests that COVID-19 vaccination should not, in general, be considered a necessary workplace safety measure, and consequently the processing of vaccine data is unlikely to be necessary or proportionate in the employment context. I've included in the description box of this video a link to the data protection guidance document discussed in this video. With regard to both publications, the release by the Data Protection Commissioner is particularly helpful. That said, many employers will not know this information or may try to disregard it. In light of same, we have drafted a template letter that may be issued to employers requesting an employee's vaccination status. And in circumstances where we receive a copy of written communications being issued to employees regarding vaccination policies in different companies, we will update this template letter as necessary or appropriate. Thanks for listening.